The Within stipulated time, I will try my level best to introduce the subject of electronic evidence. Technically speaking, the word electronic evidence is not recognized by the Indian Evidence Act. It says that it is an electronic record. So technically, this is an electronic record, not electronic evidence as per the statute. We come across in day in and day out the cases wherein the electronic record is involved, which is required to be proved by by following appropriate procedure before the court in a judicial proceedings. You know that prior to 2000, we had no law. Although we had electronic record, we had cases involving electronic record, but there was no provision giving recognition to such electronic record, say electronic evidence. But still, the Apex Court of India had interpreted such material, such electronic record in a manner so as to bring all such record within the meaning of the document as defined under the Indian Evidence Act, and therefore it was held to be admissible. If you remember some cases of telephonic recording of telephonic conversation, infringement of privacy, in the case of Indira Gandhi, that there was allegations of recording telephonic conversation by violating the privacy in violation of the Indian Telegraph Act, and though that recorded version was held to be admissible under law, although it was obtained illegally in violation of Indian Telegraphic Act. And therefore, whatever electronic versions were there, recorded versions were there, we admitted such material in evidence in view of the judgments, although there was no express statutory provisions. But as soon as there was rapid development of information and technology, we thought it necessary to have a law giving recognition to this electronic record, and therefore we brought Information Technology Act, as a result of which there were amendments in other laws, namely the Code of Criminal Procedure was amended suitably, the Bankers Book Evidence Act was amended suitably, the Indian Evidence Act was amended, and this Indian Penal Code was also amended in accordance with the provisions of the Information Technology Act. And particularly speaking about the Information Technology Act, it has given recognition to the electronic record. It has given recognition to the electronic contracts. It has acknowledged the concept of digital signature, which was not available earlier prior to coming into force this act. Because in 2000, if you see and remember, that there used to be contracts by giving a proposal from America to the person who is sitting here in India through mail, and a person sitting in India used to accept the proposal. So there is then it is a contract. But how to enforce it, whether it is legally permissible or not? Because somebody is simply offering giving an offer on mail, and other side is accepting it, whether it is a contract within the meaning of the Indian Contract Act. So those were the issues, and to remove all these anomalies and the issues, we have brought this law, which has given recognition that a contract, if it is digitally signed, then it shall be as admissible as if it is physically signed. And this is the concept we have now adopted by virtue of the Information Technology Act. Directly talking about the Indian Evidence Act, in my earlier lecture, I had elaborately discussed the issue of this fact. What is the fact? How to prove it? The concept of the documents tendered before the court. Fact, anything, state of thing, relation of thing, capable of being pursued by senses is a fact. Anything, computer, phone, mouse, book, car, fan, the cell phone, etc. Anything, state of thing, that the fan is running, that is state of thing. Truck is moving, running, that is state of thing. Relation of thing, capable of being pursued by senses. It is not stated that being pursued by senses, but it is capable of being pursued by senses, because there can be several things which may not be pursued by senses, but if the capability of human senses is increased, then we can pursue those things. That is fact. As in my earlier lecture, I had given illustration that by open eyes we cannot see, we cannot pursue that there are stars in the sky, but appropriate mechanism is applied, then we can, appropriate machinery is applied, we can acknowledge that there are stars in the sky. Whether somebody is infected by corona or not, one cannot perceive it by senses, but we can perceive it if appropriate test is applied. That is what we do. We enhance the capability of human being to ascertain that the particular person is infected by coronavirus. So that is the word employed here, is the capable of being pursued by senses. That is the fact. So whatever we can see, we can see or we see by senses, by human senses, is a fact. So is the case of electronic record. What human organs, by open eyes we can see, we can capture any incident, we can witness any incident, and the same incident is captured electronically. Then how to prove it before the court of law? If you recollect that Indian Evidence Act talks about the direct evidence. Direct evidence means a person who witnessed the incident. Say if you are a lawyer coming you are going to attend the court from your house or home. During the course of your traveling, you have witnessed an incident, and thereby you have become a natural witness of that incident. Now you are the best person to depose before the court. That is the concept, conventional concept of Indian Evidence Act, that you are a witness, direct evidence. You have told this incident to your friend B. He is not the direct witness, but he is a hearsay witness. May not be admissible, but what you say, because you have witnessed the incident, you are a direct witness, which is the best possible witness, and therefore you are required to attend the court for deposition. But what about the incident which is recorded in the electronic record? How to prove it? Whether it is a document, what is the manner of it in proving before the court of law, in proving in a judicial proceedings? These are the questions to be discussed in today's lecture. So fact, you know fact, the document means not only the papers, as I had discussed in earlier lecture, any matter expressed or described upon any substance so as to make record of it, that is called a document. And how this electronic record is a document, the next definition is evidence. Evidence means in section 3 itself has been provided. Evidence means all statement which the court permits before the court. They are the oral evidence. And second clause is there, all documents including electronic records produced for the inspection of the court, such documents are called documentary evidence. All documents are oral evidence. I'm not taking you through that oral evidence. Whosoever comes in the court, deposes, states before the court on oath, that is called the oral evidence. And the documents, documents including electronic record, meaning thereby the definition is inclusive, that within the meaning of the documentary evidence, this electronic record has been included, and thereby this electronic record can also be treated as a document as per the Indian Evidence Act. Then the manner of proving it. Now we have come to know that this electronic record is also a document, and therefore how to prove the document? There are means and modes provided under the Indian Evidence Act to prove the document. See, Evidence Act talks about evidence of what? Evidence of fact. Evidence of why? To prove the fact, and how? WWH. In my understanding, that I use this, the Indian Evidence Act hinges upon this WWH, evidence of what, why, and how. How? The manner in which the Indian Evidence Act provides. And therefore, the relevant provisions, just for the sake of today's topic, part 2 of the Indian Evidence Act is on proof. Part 2 talks about the proof, particularly section, and it starts from section 56 onwards. Section 56 onwards, but there are provisions how to prove the documents, when proof is necessary and when proof may not be necessary. Therefore, section 56, facts judicially noticeable need not be proved. The fact of which a court may take judicial notice not necessary to be proved before the court by the parties, because they are judicially noticeable. Which are the facts judicially noticeable? Section 57. There is a long list, the statutes, laws, the laws passed by British Parliament, war, articles of war, etc. I will not take you through details. But one thing, the fact judicially noticeable need not be proved. Which are the facts judicially noticeable? And then facts admitted need not be proved. Section 58. If any recorded version is produced before the court from the CCTV camera disclosing a particular incident, and the accused in that crime says, sir, yes, it is correct one, the person stabbing to B who is killed I am that person. He has not disputed his identity. He has neither disputed his identity nor disputed the incident or time, and also not disputed the authenticity of that electronic version, electronic record, and therefore no further proof is necessary. At that time, Section 58 facts admitted did not be proved. The question will come, the trouble of the prosecution or a party will come, we will start if the other side disputes the facts asserted by the party or in criminal cases by the prosecution. Otherwise, if the facts are admitted by the other side, not necessary to be proved. And the facts are to be proved by oral evidence. Section 59 provides facts admitted by oral evidence. All facts are to be proved by oral evidence except the content, except the documents. Oral evidence must be direct. Section 60. Oral evidence must be direct one. As I in my introductory remarks also, that oral evidence must be direct. A person who has heard anything, the person who heard the version or conversation, he must be the person to be deposed in the court. A person who witnessed the incident, who saw the incident, he has to be examined. So evidence must be the direct. Best evidence is the direct evidence. And there are certain rules about the primary evidence and the secondary evidence. Why I'm giving you introduction, it has relevance. It has relevance when we will be talking about the electronic record, whether it is a primary or secondary evidence. Primary evidence means proof of the documents. Otherwise, see, all the facts can be proved by the oral evidence, but documents can be proved only by the document itself. Therefore, Section 61, proof of documents. How to prove? The contents of the document may be proved by either by primary or by secondary. Thumb roll is the primary, but there are certain exceptions provided in Section 63. 61, 60, 62 says what is primary evidence? Primary evidence means the document itself, and there is also classification if a document is prepared in several parts, whether each part is a primary or not. If a document is copied, then whether the copied version is a secondary evidence, original is the primary evidence. But if a contract, I give you one illustration. A enters into an agreement with B, both have signed the agreement, duly signed by both the parties, and thereafter photocopy is prepared. Or primary evidence is that piece of paper on which there are signatures of both the parties, and photocopy is the secondary evidence. Now, other illustration. A and B have prepared the draft of the agreement contract. They have thereafter made photocopies, 2 copies. After photocopies, they have signed on each one. Each document, each contract is a primary now, because the execution is on each paper. Therefore, primary document. Likewise, the book. If a book is printed, then first copy, second copy, then 1,000 copies are prepared. Each one is the primary. Another example, newspapers. Each newspaper is a primary evidence. Although first copy, second copy, that concept is no more now. Primary evidence. Secondary evidence means certified copies. Secondary evidence, because original is always in the public office of the public authority. Very important. Section 63, subsection 2 provides copies. Section 63, subsection 2 provides copies. Copies made from the original by mechanical process is also secondary evidence. Then subsection 3 also, copies made from or compared with the original. Copies, 2 words are there in Section 63. Subsection 2 and 3 provides copies. The word itself suggests so many things, that a word copy itself shows that this is not the original, and therefore every copy or copied version of anything is a secondary evidence. This is the general rule. The question may crop up that you have witnessed incident, you have recorded that incident in your cell phone, you have prepared a copy of it, and either you have copied and pasted in your pen drive, or there are other options, import, export, or nowadays other options are there, burning option, but you have copied it. Technically speaking, it is a copy, and you have copied that incident video into a CD. Now, one piece of that incident is recorded in your cell phone, other one copied into CD. Which one is the primary, which one is the secondary? That question may arise. In the light of this provision, Section 62, 63, if we want to examine this example on the touchstone of this provision of Section 63, 64, then copied version is the secondary. But that is not the law. But in the light of this provision, whatever up till now we have gone through, that wherever there is a copied version of anything, be it a document or electronic record, it is a secondary. That is what the original concept of the Indian Evidence Act is. And Section 64 provides how to prove primary document itself, how to prove secondary, how to prove primary means document itself. Now see, if when you are going to attend the court, during the traveling, you have witnessed that incident, you have recorded it in your cell phone, and that recorded version is stored in your cell phone in memory card or the SD card, and you have prepared a copy of it, and you have kept it in a CD. Recorded version, which is original one, is the primary. Copied version is the secondary. As per this Indian Evidence Act, the conventional understanding, whatever is recorded is the original, whatever copied into CD is the copy, and therefore what the law says, the documentary evidence must be the how to prove the primary evidence by the document itself. If a person want to prove his ownership by virtue of a sale deed, then a photocopy of sale deed may not be workable. If he places on record the original sale deed, then it's all. That's all, because that is what we want. That is what the Indian Evidence Act wants. But what about the electronic record? Whether it is possible for any authority or looking to the business transactions, to keep and to produce before the court the original versions, and to keep now given in the given example, you have witnessed that incident while traveling to the court, and that original is stored in your SD card, and if the investigator wants for XYZ reason that original to be kept with him, will you go the original SD card or original your cell phone to the investigation officer? So that may not be workable, and therefore it was found necessary to have effective provisions so as to give legal recognition properly to prove the electronic record before the court of law. Section 65 talks about the cases in which secondary evidence is permissible. Then, if the original is lost, destroyed, or if the original is in the custody of the party against whom it is proposed to be proved, there are lists. If the original is a public document, then the original not necessary to be produced. But what about the electronic record? That answer is given in Section 65 onward. Otherwise, as a thumb rule, original is to be produced except it comes within the ambit of exceptions as provided in Section 65 of the Indian Evidence Act. Otherwise, thumb rule is to prove the original. Secondary is permissible, but in what contingencies the list is there. But what about the electronic record? Whether all the time original is necessary, whether there is a concept of primary or secondary evidence, these are the issues. Now, Section 65A says the word employed is special provision. Special provision as to evidence relating to electronic record. Special provision. In the entire Indian Evidence Act, the word special is used is here. And therefore, the word is very much significant. Special provision. Special means it is not a general. You know, if a special train is arranged by the government, this is not the general train. It is a specially arranged. Special flight is arranged. It is not the general flight. It is a specially arranged. So likewise, this provision is a special provision, not a general provision. Meaning thereby that other provisions are general provisions and this is the special provision. Section 65 says it is to be proved, electronic record is to be proved in accordance with the provisions of Section 65B. What 65A says? Electronic record is to be proved in accordance with Section 65B. Now, what Section 65B says? Admissibility of electronic record. Now, see, this is also a part and parcel of 65A special provision, and this is Section 65 is also a part and parcel of the special provision. This is not also the general provision. If we see the very beginning of the section, we will realize that this is again a special provision. See, notwithstanding anything contained in this act, notwithstanding anything contained in this act. So whatever is stated right from Section 1 to Section 65 and whatever is stated after Section 65 AB till the end of the statute book, this provision shall prevail. That is why I am giving stress on the word special. This is called a non-obstante clause. Wherever such a clause is provided, either in the contract, in statute book or any code, then it gives go by to all other provisions. Those provisions become irrelevant insofar as this special clause is concerned. This non-obstante clause, by incorporating this provision, of non-obstante clause, other provisions are given go by. Insofar as electronic record is concerned, I'm not talking about the other evidence such as the oral evidence or the documentary evidence, but only in respect of the electronic record there is a special provision. Otherwise, other provisions right from 1 to 65, they are the relevant provision insofar as other piece of evidence, either other nature of the evidence is concerned. But insofar as electronic record is concerned, this is special provision. It has to be proved only in accordance with section 65B. Section 65B, the opening word says notwithstanding anything contained. For the benefit of the viewers and the listener, that I will take you through that definition itself. Notwithstanding anything contained in this act, any information contained in an electronic record which is printed on a paper, stored, recorded, copied in optical or magnetic media, produced by a computer, which is called a computer output, shall also be deemed to be a document if the conditions mentioned in this section are satisfied. So whatever electronic version, if it is stored, prepared, or printout of it is taken, it shall also be called as a document if certain conditions are fulfilled. Now see, at the very beginning, while looking the definition of evidence in section 3, then there is a clause, all documents including electronic record shall be documentary evidence. This is again, it has been provided in section 65B that whatever electronic version, if it is stored, printed, or kept anywhere in electronic magnetic media, it is also a document if certain conditions are fulfilled. And it shall be as admissible as other documents without without calling for the original. If I may touch to the section, if the condition mentioned in this section are satisfied in relation to the information and computer in question, and shall be admissible in any proceeding without further proof or production of the original as evidence of any content of the original or any of the facts stated therein of which direct evidence would be admissible. Now this is the very important section insofar as electronic record is concerned. Now see, even if it is a copied version, section 63, if you now recollect, which I have taken you through that section, copied version is a secondary evidence. Any document copied mechanically is a secondary. Now here copy is also admissible without production of the original if it satisfies certain conditions. And this special provision itself provides that no original is required insofar as electronic record to be proved in the court if certain conditions are satisfied. Which are the conditions? Section 65B itself provides certain conditions, which I will discuss. Now see the comparison. What the original Indian Evidence Act says, primary evidence is admissible. What is primary evidence? What is secondary evidence is defined. When secondary evidence is also permissible, but when certain conditions are there. Now this is complete go by to those provisions. It says without production of the original, this electronic record shall be admissible, and it shall be as admissible as if it is the original document, although it is a copy. Otherwise, section 63, if you now recollect, copy is a secondary. But that provision is not applicable insofar as electronic record is concerned. The concept of copy is secondary. That is not true insofar as electronic record is concerned, which is evident from the reading of section 65B. And therefore, always it may not be necessary to produce the original. If the original electronic record is produced, then okay, no problem. But what it is enabling provision, original, if now see the same example which I am repeating, that from your home you are going to attend the court. During the course of traveling, you have witnessed an incident that A stabbed B in your presence, and you have not only witnessed that incident, but you have recorded that incident in your cell phone. That recorded version is stored somewhere, either in the SD card as per the setting of your mobile. That recorded version is the original, and if there is no such provision, then this original would have to be handed over to the investigation officer. Your cell phone has gone now. Your original SD card has gone now. What about the electronic record of your personal nature, which is already stored there? So law cannot be so absurd that in each and every case, bring original electronic record. If we insist for the original electronic record, things may not be proved, and it will be a very difficult situation. Then what option you have? You have prepared a copy into a CD and that CD is handed over by you to the investigation officer. Now, as per section 63, it is a copy, and copy is a secondary evidence. But now see, we are in section 65B. It says, no, this is not the secondary. It shall be as admissible as the primary evidence, as without production of the original, if certain conditions are fulfilled. If word is employed here. Which are those conditions? Then subsection 2 comes into picture. The condition referred to in subsection 1 in respect of a computer output shall be the following. Now see, subsection 1 talks about the condition in respect of computer output. The computer containing the information was produced by the computer during the period over which the computer was used regularly to store or process the information for the purpose of any activities regularly carried on over the period by the person having lawful control. I'm repeating, I'm deliberately, intentionally repeating this word, having lawful control. Earlier was the law. What is material is the evidence. In what way he has produced before the court, in what way he has procured is immaterial. It is evidence is the evidence. Now that concept has also gone. The person who is producing electronic record must have lawful control. Earlier, in my introductory remark, I had given an example. There was a case wherein evidence was collected that telephonic version was recorded illegally in violation of the provisions of the Indian Telegraph Act. Section 25, Section 27 was violated. The Honorable Apex Court of India held that though it may be prepared in violation of the law, but it is evidence after all, and we are here to find out the truth, and therefore it shall be admissible. Now here is very important provision incorporated that a person, that computer, whosoever is handling, he must have lawful control. His computer must be in operation. Data must be regularly fed into it. I will give you two illustrations of this. That one, if you go in the bank to deposit your amount, you hand over to your amount to the cashier. Cashier simpliciter, he counts the currency notes and takes entry in the computer. See, 1,000 rupees was already there in your saving bank account. You have deposited one more, that 2,000 rupees now. Cashier does not count that you have already 1,000 and how much you have given, 2,000. And how much is the interest? Now 3,300. He does not bother to calculate. Who calculates it? The computer. Because data is regularly fed into it. It is in operation. And during that period, it is in lawful control of that cashier, manager, whosoever, bank official. That is the condition of the computer. That computer must be in operation. There must be regular activities of recording that data, and that computer must be in lawful control. And other conditions are there. I will sum up those conditions in simple language because technical words have been used. That even if the computer is not in operation, but at the time of relevant fact, at the time of the relevant incident, it started functioning. After the incident is over, it again stopped working. I will give you an example. Now see, one example of bank I have given to you. Other example, that a CCTV is installed in front of your home or office, and in front of that CCTV camera, an unfortunate incident occurs that A stabs B. That is recorded in CCTV. Data is stored somewhere. Then how to prove it? See, now CCTV is on throughout 24/7. Data is regularly fed into it bit by bit. It is stored somewhere as per the capacity of your device. Now that stored material, relevant material. So that is what the Indian Evidence Act wants, that the data must be regularly fed into it. It must be in operation, and you should have lawful control. That is the example of CCTV camera installed in front of your office. Now, third example, that you have installed that CCTV camera, but after installation of it, the functioning of it stopped. After one day, on the day of the incident, it started, and whatever happened, the incident of A stabbing B has been recorded in that CCTV. After few hours, again it stopped working. So prior to the incident, it was not operational properly. After the incident, also not operational. Only it operated. It started working during the course of that incident. Still, it is admissible, provided that the non-functioning of the device or your CCTV camera prior to the incident, non-functioning of this device or your CCTV after the incident may not affect the accuracy of the information. Information means this electronic evidence, this video, that is called the information. See, information means output. You capture your image. There are thousands of images made up of thousands of pixels. Then image is prepared. We acknowledge, or you acknowledge that this is me, or you. That is called information. Data is always raw. So pixels data, it gives information is the image. Whatever the video is the information contained in the computer. While recording that information, there are several mechanical process happen. The data works, data and information. Now I will give you the illustration. See, the director of prosecution or the government, how data collects. Now, what is the percentage of conviction in the state of Maharashtra? So the information will be called, data will be called, in fact, from Gadchiroli district, Chandrapur district, Satara district, Sangli district, how many persons have been convicted. Then district-wise data, then taluka-wise data, and then division-wise data, and then there is a clear information that there are 71% conviction in the state of Maharashtra, or 51% conviction. This is 51% conviction in the state of Maharashtra is the information. Wherefrom we have got this? By collecting the data. So data is all data. The information is a super form of the data in simple word. So this information, so whatever video we can see is the information which is made up of data. So that information must not be corrupted, must not be hampered because of non-functioning of the device. These are the conditions. Number one condition, that the computer must be in operation. It must be in lawful control. Then data must be regularly fed into it. And even if the computer is not in operation, but at the relevant time it is in operation, but any kind of default or technical snag of computer must not have affected the accuracy of data. These are the conditions to be fulfilled insofar as electronic record is concerned. And one more condition, very important condition, that there has to be someone who will identify the data electronic record information which I have handed over, or which I am giving to you, to the investigation officer, is accurate. Now see, I will give you one example, that if you go to the office of sub-divisional officer or the collector office for securing any certificate or getting certificate, legitimate certificate, for you are the domicile of the state of Maharashtra, you need to have certificate, caste certificate. If you go to the office of sub-divisional officer for obtaining caste certificate, you will apply, and the learned SDO will give you the caste certificate without signature. There is no physical signature nor digital signature, no any stamp, but there is a simplicity written that you are belonging to particular caste. Whether it is a valid caste certificate, certainly not, because there lacks authenticity of that certificate. Who will give authentic? Who will? If there, on the contrary, if the caste certificate is issued by the learned SDO, duly signed by him, there is a stamp, there is a proper outward number, date. This is authenticity. Another example, that you have received a letter. I am at Nagpur and I have received letter from Mumbai. There is no postal stamp. So the first thing in my mind will come, how this letter has come to me without any post stamp. It means that somebody has played with me. Somebody has directly put that letter in my postal box, in my post box, purporting to have been issued from Mumbai. In fact, it has not been issued from Mumbai. If it was issued from Mumbai post office, then firstly there would have been the stamp, postal stamp of Mumbai. Then then the middle course Nagpur, then it would have reached to me. If there is no stamp, I would have raised suspicion. So this stamp seal gives authenticity to any document. If you applied for the building, if you want to construct a building, or any builder wants to construct a building, he needs the sanction from the authority. Sanction is granted. The learned municipal commissioner says sanction is granted to you. You go and construct. Will it be permissible? Or simply later he has given permission is granted for construction. No signature, no stamp, not legal. What I mean to say, that the signature, seal, stamp show the authenticity of the document. Now, in the now other example, if you lodge a report, being a lawyer, same example, that you are while traveling to your court from your home, you witnessed an incident of A stabbing B, you have recorded it, and you have directly gone to the police station for lodging a report. And if you have lodged the report at the police station stating that on so and so date while coming to home, I have seen an incident that A stabbing B, at so and so place at so and so time, and you have signed that FIR. Subsequently, if it is found that FIR, no such incident has happened, what Mr. Lawyer is saying is absolutely incorrect. A is alive, A is somewhere there, and B is alive. How this lawyer is lodging a report that B is killed by A? Absolutely false FIR. Whether you can be taken to task or not, whether you can be prosecuted for lodging a false information, for lodging a false report, for giving false information to public servant, you can be prosecuted because there is a signature of you on the first information report lodged by you. Now, on the contrary, about the same incident, you have simpliciter handed over the CD. You have allegedly seen the incident. You have recorded that incident, stabbing B, prepared a CD, and you have handed over to the investigation officer. You have not signed any document. Subsequently, it is same thing is found that no such incident happened. It is animation work. A never killed B. B is alive and A is in USA. Can you be prosecuted? Tomorrow you are free that I have stated that A has killed B. Is there my signature? Have I made any allegations? I have simply given this electronic record. I have not given you assurance that this is correct one. You are free now. That is what the legislature wanted to avoid, and therefore concept of certificate is necessary. Why for this certificate is necessary? I have given you these examples of issuance of caste certificate by the SDO, issuance of the sanction for construction duly signed by the authorities, duly sealed and stamped of the authorities, postal stamp. This certificate as contemplated in section 65B is what? Is nothing but is an authenticity given to the electronic record. Now see, I am directly coming to that part of certificate. In the same given example, you have handed over that copied version to the investigation officer, stating in writing that today, while going to the court at so and so time, I have seen an incident of A stabbing B. I have recorded that incident in my cell phone, and thereafter I have prepared a copy of it into a CD, and the same CD I am handing over to you. As per my knowledge and belief, it is correct one. This is the correct. The CD contains correct and true information, and there is a signature of you. And subsequently, it is found that no such incident happened. That CD is absolutely fabricated one, doctored one, engineered one, or absolutely bogus one. You can be prosecuted because there is a signature of you. You had given authenticity. Why that is why the certificate is necessary to give authenticity to electronic record. Who can give it? See the earlier condition, a person must have lawful control. A person who is in lawful control of electronic record, lawful control or the management of the electronic record can issue a certificate. What are the requirement of the certificate? Section 65B4 says that the person is giving the certificate must identify the electronic record, giving such particulars of any device involved in the production of that electronic record as may be appropriate. See the word, such particulars as may be appropriate. Such particulars as may be appropriate. Now see, I will give such particulars as may be appropriate. How? If I am the person who is recording that incident of A stabbing B, and I have recorded that incident and copied the incident into a CD. Such particulars means that I will state in my certificate that while going to attend the court on so and so date at so and so place, I have seen this A stabbing B. I have seen this incident, not only seen but I have recorded in my cell phone of so and so company. I am the owner of that cell phone. I have, if necessary, may be incorporated that I have purchased this cell phone from so and so person by so and so bill, and thereafter that incident is recorded in my SD card or in particular folders are there in every device. In which folder it is stored, I can mention that this device is mentioned, that the electronic record is stored in XYZ folder, and thereafter I connected my cell phone to a computer, and thereafter I directly visited to that folder or click to that folder, and thereafter copied that folder by the option of copy, and then paste that electronic record into the CD by the option of paste, which is available in my device, in my operating system. And This CD contains the same data which I have copied, which is recorded by me by my cell phone, and the electronic record is the same, is of the same incident which I have seen. And as per my knowledge and belief, this information is true to the correct, is true and correct to the best of my knowledge and belief. That's all. This is the signature. That is what the law wants. Law wants. No more, no, nothing more, no, neither more nor less. These are the niceties to be incorporated into the certificate by the person either who has recorded the version or who has managed. Other example of managing. Now see, in the bank example, you have credited the amount, automatically bank software calculates what is the amount, what is the interest, and even a dispute is there in respect of your account, whether original computer is taken or whether original hard disk is taken, it is never taken. What the manager does, he simply takes the printout. It is called computer output. He takes the printout and he issues the certificate stating that it is correct one. It has admissibility in evidence. In fact, he issues the certificate as per the Bankers Books Evidence Act. Again, that is a special law. This special provision in contemplated in section 65 is a special insofar as Evidence Act is concerned. Otherwise, Bankers Book Evidence Act is again a special provision. So, if you say, if a person issuing the certificate has a lawful control or he is managing, is the right person to issue certificate. That the manager does not operate computer personally. It is the accountant, it is the cashier, whoever may be employed there. They are operating the computer. But the certificate is always issued by the manager because he is in a managerial capacity. He manages. So section 65B subsection 4 says, by the person who is responsible official position in relation to the operation of the relevant device or the management, a person who operates the computer or who manage the device, they are the right person to issue the certificate. And once any electronic record is produced in the court of law coupled with this certificate, then it is admissible. If there is no certificate, it is not admissible. One more thing, if when it is necessary, if the original is not produced, and if the original itself is produced, no need of certificate. See, certificate as contemplated in section 65B would be necessary if it is a copied version. Then these conditions will have to be ascertained, established. But the original is produced, then certificate not necessary. Original version itself is necessary to be produced in the court, to be inspected by the court. That is what the law stands today. Now we had some confusion. Earlier was the decision in Navjot Sandhu case, Parliament attack case. The Honorable Apex Court had held that even if there is no certificate identifying electronic record, but those computer output, those call records were duly certified by the nodal officer. He had issued, and law says as when the original is not primary evidence is not available, then secondary is permissible. Law says so, and therefore even if there is no certificate, secondary evidence is permissible, not necessary. That certificate is not necessary. That judgment was delivered. That was in fact in the light of the earlier provisions. But thereafter, other than judgment 3 judgment came in, which says no, there is a clause, non-obstante clause is provided, which talks about PV Anwar judgment, the Honorable Apex Court, that provides that the clause is there which provides notwithstanding anything contained in this act, meaning thereby the old concept of primary and secondary that has gone. What is required is as per the requirement of this section 65A and B, insofar as electronic record is concerned and law is laid down, that whenever there is a question of electronic record to be proved in the court of law, if it is the copied version, then certificate would be mandatory. If it is not the copied version, then the certificate may not be necessary. So I hope that I have explained the concept of evidence, then electronic record, document, and how it is admissible in the court of law in a judicial proceedings. Otherwise, in society it is admissible as you can show video to anyone. Other person may believe it, and there are so many quarrels and the riots that take place on the basis of the video. no writers want to see the certificate whether it is authenticate data or not. But insofar as proceeding, the word employees in any proceedings, proceeding means the judicial proceeding. If a question of electronic record arises, it is to be proved in a manner provided under this section 65B. That's all for today's topic.
Sir, may I ask my question?
Yes.
Okay. Question is related to Maharera website. That is also electronic evidence. Now, if there is a what you call cross-examination of the evidence, which I want to submit to the court, to the tribunal, that relating to the construction stage, how much is completed, and that is available on the website of the builder. So in that case, who will give the certificate?
That you have now, see, you are the person, you are in a civil proceeding now. If you want to produce that data, you have to take the computer output, the the computer printout of that electronic record.
Right.
Website. Now it is for you because you are producing that. Then you will have to explain in the certificate that there is a website of so and so which is in public domain, and it is provided by so and so builder, and you have taken the printout of that original website from original website, and the printout which you are producing before the RERA authority is the same which is available there on the website of that person. Because in civil proceeding, what is the best possible? Or you can engage a professional, you can take assistance of him, who will also again take printout and will do the same thing. Whether what is the source or not, it is you, that those things are not in your hands. It is for the investigation machinery. If there is a police complaint, then they will find out the website, the source, domain name, etc.
So there is no investigation. It is just
it is in civil proceeding. It is for you to take printout stating accompanied by the certificate.
Who
And
issues the certificate?
you will have to mention that I am so and so person using this computer, and I have so and so PC. I am having lawful control. That there is a website called so and so www and so, and that website belonging to so and so person. I have taken printouts by the option of copied or print, directly print, or you have copied those data from the website and thereafter printout is taken, or you have directly taken the printout by option of the print, and the computer, your computer is operating properly, the data is not manipulated, that the data which you have taken printout is not corrupt one, and therefore whatever is contained in this electronic record, this computer output is the correct as per my knowledge and belief. Insofar as it is the original is concerned, original is there where on the website, and you have only printouts. So you will have to mention all these details, showing that you have taken the printout from the right source, and those are the same as per the original, to make it admissible in Evidence Act.
So it's more like a declaration more than and less of a certificate.
Yes, but
it's more a declaration.
The word which we have employed here is the certificate.
Okay, right, sir. Thank you so much.
In fact, you are declaring, you are technically word is used the certificate, but otherwise it is a declaration, self-declaration.
Right, sir. Thank you.
Okay.
I wanted to ask whether electronic evidences are admissible in consumer court or what?
They are not bound by the provisions of electronic by the provisions of the Indian Evidence Act. They are the forum. See, no tribunal is bound by the provisions of Evidence Act. They are free to adopt their own procedure. It is a forum, so less standard of proof is required. They are not. They are strictly Evidence Act is not applicable to them.
Even in case if we have some valuable evidences in the form of electronic.
Yes, you can produce. But while producing, take care that it is produced in accord. When you are producing it, produce in a way which is admissible under law. So better to have certificate as I have explained to you. So electronic record, if you are producing, produce it, but coupled with the certificate. Otherwise, electronic record, the forum may not take it.
Okay. Thank you, sir.
Welcome.
Is WhatsApp chat considered as evidence in court of law, providing the mobile is damaged, but email is the same where chat is exported?
Yes. See, this digital evidence, electronic record is never the matter of total deletion, permanent deletion. There is no concept of permanent deletion insofar as electronic record is concerned. Whatever chats that person wants to produce, those must be stored somewhere. The digital footprints are never destroyed. They will be there forever. He can temporarily destroy, but that electronic record material can be revived, restored, retrieved, provided that appropriate machinery is used. And therefore, whatever chats are there, see, if I have received an offending message on my WhatsApp, what is the mode and mechanism to prove it? That I will say, I will take printout. I will not hand over my original cell phone to the court or the investigator. I will take the printouts. While taking the printout and while producing before the investigation officer, I will have to ascertain that I have received this offending message from A having cell phone number so and so, of which I have taken printout by this and this option. Those printouts are the same. Now, whether it is from the same person or not, there can be prank or there can be manipulation or not. That is a matter of investigation. But printouts of that email also, as well as the WhatsApp, are admissible, provided that they are accompanied by the certificate, because they are computer output. They are computer output.
Okay. Can we self-certify 65B certificate? If no, who is authorized for providing 65B certificate? Along with that, second one is, can we get the format of 65B if old events are recorded, past dated? Is there?
Yes, I understood. That format is not provided in the statute book. I have prepared some formats looking to the needs, because I was trainer for the public prosecutor for at about 4 years. So I used to prepare those draft and used to give them. Looking to the or case to case basis, those can be prepared. There is no standard format of the certificate, and therefore requirements must be there as provided in section 65B.
So the next question is, can a person wrongfully accused admit CCTV footage of which he himself is the owner of the said CCTV device?
If he is admitting, if he is admitting, then no problem. I know that protection of self-incrimination may come, but if he is admitting, because that admission, simpliciter admission is not sufficient, it is corroborated by the electronic record. So it is admissible under law. He has protection of self-incrimination. No one can force him to admit it. But if he has voluntarily admitted and his admission is corroborated by the electronic record, I don't think any problem to be acted upon such a admission. In fact, it is a confession because he is accused in the same crime.
Okay, sir. Can the examination of witness be done via video conferencing, and
Yes.
will it be admissible in the
Yes. Earlier, judgment was there that a person presence means not the physical presence, but a presence through the video conferencing. But now there are express provision. It is permissible.
Okay.
Provided that the identity of the deponent will have to be ascertained by the parties. It should not be in dispute.
Okay. If there has been online slander and the original article or tweet was deleted, can the admission of a witness be enough to prove that it was made by the said person?
Admission is not sufficient. It has to be always supported by the evidence.
Okay.
In criminal law, if it is we are dealing with the criminal law, then there has to be evidence. Mere admission is not sufficient.
Okay, sir. Okay.
Okay, thank you for inviting me.